I write on Substack, and I just wrote this post about the Supreme Court. I figure it's more likely to get noticed on YouTube than it is Substack, so I've decided to just read what I've wrote. Read what I've written? Either way, it's called the All-Supreme Court. Another day, another precedent set to be overturned. The Supreme Court heard oral arguments on a case called National Republican Senatorial Committee versus the Federal Election Commission. The question before the court is basically this: are limits on how much political parties can spend in an election unconstitutional? The FEC says they can regulate it. The Republicans say, to hell with the law, we want to raise and spend as much money as possible. Knowing the Roberts Court, they are likely to agree with the Republicans in this case and flood our elections with even more dark money. The court has had a long history of doing that, far predating John Roberts. In order to understand exactly what's going on, it might help to look back at some related cases. Let's start with 1976's Buckley versus Vallejo. The lawsuit was filed by Republican Senator James Buckley and other conservative groups. He wasn't a Republican at the time, but that's what he is. The court released a complicated per curiam opinion that sided with Buckley and said parts of the Federal Election Campaign Act of 1971 are unconstitutional. Specifically, the limits it imposed on candidate campaign spending, limits on how much individuals could donate to campaigns, how much a candidate could donate to their campaign, among other things. Later, in 1996, the court took up a case, Colorado Republican Federal Campaign Committee versus the Federal Election Commission. This case was caused when Colorado Republicans took out an ad against Democrats, and the FEC said they were in violation of the previously mentioned Federal Election Campaign Act of 1971. Republicans said they weren't endorsing a specific candidate with the ad, which means they weren't breaking the law. In a 7-2 decision, the court found that not only had Republicans not broken the law, political parties are protected by the First Amendment to spend as much money as they want, as long as they don't coordinate with a particular candidate. This case has come to be known as Colorado 1. This is because, in 2001, the court took up another case, Colorado Republican Federal Campaign Committee versus the Federal Election Commission. That case is now called Colorado 2. This case asked if congressional campaign spending limits on parties are unconstitutional in general. In a 5-4 decision, the court said that the limits were constitutional. They added that ads made by a party in support of a candidate, but without coordination between the two, was indistinguishable from an ad made by a party coordinating with a candidate. It might seem a little complicated. Basically, the court said voters can't reasonably tell if a political ad is made by both a party and a candidate, or just one or the other. If voters can't tell who's making and paying for an ad, it leaves the door open for corruption. Therefore, the government has an interest in making sure there are limits in place on how political parties can fund advertisements. Following Colorado 2, Congress passed the Bipartisan Campaign Reform Act of 2002, commonly called the McCain-Feingold Act. It addressed some issues with campaign finance and put regulations in place to limit the amount of money that could be donated to political parties. The Republican ghoul, Grim Reaper, Mitch McConnell, tried overturning the law in the 2003 Supreme Court case McConnell versus the FEC, but he was unsuccessful in doing so. That was until 2010. Campaign finance laws were weakened significantly in the 5-4 ruling in Citizens United versus the FEC. In this case, Citizens United, a conservative group, wanted to air a documentary on Hillary Clinton, and they wanted to do it within 30 days of the Democratic primary of 2008, which was against the McCain-Feingold Act. The case was fought for 2 years until the Supreme Court sided with Citizens United and ruled that limits on political expenditures by corporations were unconstitutional. And that brings us to the current case, the National Republican Senatorial Committee versus the FEC. As I said at the start, the court is going to rule on whether limits on political party spending is unconstitutional. I've mentioned 5 Supreme Court cases relating to campaign finance. All 5 were brought by Republicans. 4 of the cases were initially successful, and the one losing case, McConnell versus the FEC, ended up being overturned by Citizens United. So I'm going to ask you, have things improved since then? Have our politics improved at all? Have all these multi-million and billion-dollar campaigns helped the country in any way? Do Americans like having billionaires controlling our elections? Do we like having businesses buying up politicians with unlimited donations? Here's a question for Republicans. Do you like George Soros? Here's a question for Democrats. Do you like Sheldon and Miriam Adelson? Their ability to fund elections and candidates without limits is because we can't seem to impose any limits on campaign finance. Now, how will this current Supreme Court case go? Who knows? The oral arguments didn't make the court seem inclined to go one way or the other. However, based on the court's recent history over the last 50 years, I expect Republicans will get their way once again, and the country will suffer as a result. So that's what I wrote on Substack. If you like what you heard, go follow it over there. Maybe follow me here. So far on Substack and YouTube, I have a combined 0 subscribers. So I'm just shouting out in the void right now. Oh well.